just to try and get some sense of where we are on this one. For those of you that are not 100% sure of where we are and where we come from, there was a Supreme Court of Appeal decision on the 2nd of November 2020 that basically said that the minister acted outside his powers for putting together the Preferential Procurement Regulations of 2017. That resulted in an order of the Supreme Court of Appeal that declared the regulations to be invalid, declared the Preferential Procurement Regulations of 2017 to be invalid. But that order of invalidity was suspended for a period of 12 months from the date of this order. So the Supreme Court of Appeal, 2nd of November 2020, said that the Preferential Procurement Regulations 2017 are invalid, but that order of invalidity was suspended for a period of 12 months from the date of this order being the 2nd of November 2020. National Treasury let us know that it was then challenged or appealed, that decision was appealed, that notification came on the 4th of December that we saw. They said that clearly the Minister of Finance now has appealed the judgment of the Supreme Court of Appeal, and that was then early December. We now know, based on the 30th of May final judgment of the Court, that that appeal happened 21 days after the 2nd of November. And why this is important is because, and you can see here there's reference in the judgment on Monday to Section 18 of the Superior Courts Act. And what that Superior Courts Act says is that when an appeal is lodged, the decision of the Supreme Court basically was then halted at that point in time. The Court then, and I've got to get this date right here, the Court then gave us its judgment on the 16th of February 2022. I must make sure that we get that right because it's an important one. So on the 16th of February 2022, the Court gave its decision on the appeal. Basically said that it was neither necessary nor was it expedient for the Minister of Finance to issue the regulations that it did. It spoke very, very much around this whole definition of what does necessary or expedient mean. The upshot is that the Procurement Act, they said, was enough, and that it was neither necessary nor expedient for the minister to issue regulations. The Court basically said that the appeal by the Minister of Finance was dismissed, and therefore the decision by the Supreme Court of Appeal stands. Please, we've got lots of lawyers online. If there's anything that I'm saying which is not legally correct, please do come in and assist me. In that Court decision, there was a footnote in the minority judgment of the Court decision that said that the period of suspension, which is the suspension of that order of invalidity, that period of suspension ended on the 2nd of November 2021. And this is what, through National Treasury, they had not expected that. They expected that the Superior Courts Act would have put on hold that countdown after day 21. And this was not something that National Treasury expected. As a result of that, National Treasury then wanted to go back, did go back to the Court to seek urgent clarification on that matter. And because they were unsure what it meant, they basically advised the state to put on hold tenders and quotations from the 16th of February. There was a process that followed that allowed organs of state to apply for exemption, etc. And yeah, let's see. So the Court came back on the 30th of May with its final decision. It was a unanimous decision, and the upshot of that is summarized in National Treasury's press statement that they put out in the afternoon of Monday, the 30th of May, basically saying that Section 18 of the Superior Courts Act suspended the operation of the Supreme Court of Appeal's 12-month suspension. In practical terms, the countdown on the 12-month period of suspension commenced immediately after the date of suspension, but that countdown, however, was halted by the lodgement of the application for leave to appeal in the Constitutional Court. We know that was 21 days after the 2nd of November. The countdown resumed on the 16th of February 2022 when the Constitutional Court dismissed the appeal against the Supreme Court of Appeal. Therefore, the 2017 regulations in their entirety are valid. From today, being Monday, the 30th of May, all exemptions granted to deal with the period of uncertainty following the court's judgment on the 16th of February lapse. Immediately on the issuing of the judgment by the Court, those exemptions that National Treasury granted, or the Minister of Finance granted, to organs of state, giving you exemption on provisions of the Preferential Procurement Policy Framework Act, those exemptions fell away immediately. From that point onwards, from Monday onwards, therefore, all quotations, all tenders must be advertised and dealt with in accordance with the 2017 regulations. There is no further exemption, there's no further vagueness or uncertainty. The 2017 Preferential Procurement Regulations apply. They've applied from the 16th of February 2022, unless you had an exemption. What they then say is that the quotations that you requested or advertised under the exemption, those basically should be able to be continued to be evaluated on the basis that you advertised. I'm not sure why National Treasury then put in this other statement here. An organ of state may, however, decide to withdraw such a request for a quotation or an advert for tender and request a new quotation or advertise a new tender that will be subject to the 2017 regulations. I'm not sure why they've said that. I have seen a legal perspective from one of the respected attorneys to say that you should actually cancel and start again. I am not sure why that is the case, but that certainly is there. My understanding of the Section 6 of the Preferential Procurement Policy Framework Act is that it makes provision for a transition period, which clearly says that if you've advertised something before this act is effective, then you must continue to evaluate the tenders and the quotations as if this act did not exist. That's what 6 says in the PPFA. There is a statement, and you'll see that I did cover the date in the early part of the statement. There is a date, a reference to 15th February 2023 to say that the 2017 regulations will remain in place until the 15th of February 2023 unless new regulations are promulgated before that date. My understanding is, and I've had a number of lawyers that have confirmed this, is that this 15th of February reference is wrong. It does not take into account the fact that the Constitutional Court said the clock started ticking again on the 22nd, which means that 21 days have gone, which means that we've got to subtract from the 15th of February 21 days, and by my calculation, that puts us at about the 25th of January 2023, which means that the regulations, from my perspective, and a couple of people have confirmed this, will lapse on the 25th of January 2023, which means, therefore, that if you want to be ready for the 25th of January, you probably need to start working on your policies well before then, so that you can have a draft preferential procurement policy, a draft SCM policy finalized before people go on leave, so that your boards, your accounting officers can approve that before they go away, so that when they come back, you don't have any issues on the 25th of January.